Phoenix, Arizona, June 17, 2018, a sweltering Sunday afternoon when most of the city sought refuge from the 104-degree heat. Inside the Maricopa County Police Department, Detective Elaine Mercer sat alone in the nearly empty building, meticulously organizing the final pieces of evidence for what she believed would be the most significant case of her career. After 14 months of careful investigation, working nights and weekends, she had compiled overwhelming evidence of systematic abuse of power within her own department. The daughter of a third-generation police officer, Mercer had joined the force with idealistic visions of continuing her family's legacy of public service. Her grandfather had marched with Dr. King. Her father had been one of the first black officers to reach the rank of captain in Phoenix. Elaine had graduated top of her academy class and earned commendations for her work in community policing initiatives. Her colleagues described her as methodical, principled, and unflinchingly honest, qualities that had made her an exceptional detective but would soon make her a target. The investigation had begun innocuously. A routine internal affairs complaint that landed on her desk in April 2017, allegations of excessive force during an arrest in the predominantly Hispanic neighborhood of Maryvale. What should have been a straightforward case soon revealed disturbing patterns, the same officers' names appearing repeatedly in similar complaints, missing body camera footage, witness statements that contradicted official reports, and most troublingly, cases that were consistently dismissed or buried before reaching proper channels. By August 2017, Mercer had identified at least 14 incidents involving 8 officers, all under the direct command of Lieutenant Blake Tanner, recently promoted to commander of the Southwest Precinct. Tanner, a decorated veteran with political aspirations and powerful connections throughout Arizona law enforcement, had cultivated a loyal group of officers who operated with apparent impunity in certain neighborhoods. "I remember the exact moment I realized how deep this went," Mercer would later testify. "I was reviewing body cam footage that supposedly didn't exist according to official records. An officer was heard clearly saying, 'Tanner said no cameras on these stops.' That's when I knew this wasn't just a few bad officers. This was systematic." As her investigation expanded, Mercer began noticing subtle changes in her work environment. Colleagues who once greeted her warmly now passed with barely a nod. She was excluded from meetings. Assignment schedules were altered without explanation. Her direct supervisor, Captain Jerome Walsh, began requiring additional documentation for her ongoing cases, paperwork not required of other detectives. By November 2017, the pressure had intensified. Anonymous notes appeared in her locker, "Back off," and "Some things are better left alone." Her case files were repeatedly accessed without authorization. When she reported these incidents, they were dismissed as departmental oversight or computer glitches. In January 2018, Mercer formally presented her preliminary findings to Internal Affairs Director Regina Alvarez, documenting patterns of abuse, evidence tampering, and what appeared to be a coordinated cover-up reaching into the department's upper echelons. Alvarez, visibly disturbed by the evidence, promised a full investigation and assured Mercer of confidentiality. 3 days later, Alvarez was reassigned to Traffic Division, a stunning demotion for a 20-year veteran with an impeccable record. Her replacement, Marcus Denton, a close associate of Commander Tanner, immediately labeled Mercer's investigation procedurally problematic and ordered a comprehensive review before any action could be taken. What followed was a masterclass in institutional obstruction. Key evidence began disappearing from secure storage. Digital files were corrupted or deleted during system upgrades. Witnesses who had previously provided statements became unreachable or recanted, citing misunderstandings. In March 2018, Mercer elevated her concerns to the District Attorney's Office, meeting personally with Assistant DA Reed Donovan, providing him with duplicate evidence she had prudently secured. Donovan, known for his tough stance on police accountability, assured her the matter would be thoroughly investigated. By April, Mercer found herself reassigned to cold cases, physically relocated to a basement office with limited access to departmental resources. Anonymous calls began reaching her home phone. Her personnel file was suddenly flagged for performance review, despite her consistently exemplary evaluations. "It was like watching dominoes fall," recounted Officer Luis Mendoza, one of the few colleagues who maintained contact with Mercer during this period. "Everyone could see what was happening, but nobody wanted to be next." The message was crystal clear. Support Mercer and your career is over. On May 15, 2018, Mercer received an email from the DA's office that would change the course of her life. The investigation into her allegations was being closed due to insufficient corroborating evidence and procedural inconsistencies in evidence collection. The email, curiously, came not from Donovan but from his superior District Attorney William Hargrove, a longtime friend of Police Commissioner Raymond Sullivan. When Mercer attempted to contact Donovan directly, she discovered he had taken an unexpected leave of absence. Calls to his office were redirected. Emails went unanswered. It was as if he had simply vanished from the justice system he had served for over 15 years. The final blow came on June 20, 2018, when Mercer was summoned to Commander Tanner's office. For the first time since her investigation began, she found herself face to face with the man whose name appeared throughout her case files. "I've always admired your dedication, Detective," Tanner said, his voice carrying the practiced warmth that had won him community service awards and political endorsements. "But I'm concerned about your health. Several colleagues have noted signs of stress, paranoia even." The meeting concluded with Mercer being placed on administrative leave, pending psychological evaluation. As she surrendered her badge and service weapon, Tanner added, "Sometimes we see corruption where there's only complexity. The department appreciates your service, but perhaps it's time to consider whether this is still the right profession for you." By the time Mercer returned to her desk to collect personal belongings, her computer access had been revoked. Her case files, 14 months of meticulous investigation, had been officially archived, classified as inconclusive, insufficient evidence to proceed. That night, alone in her apartment surrounded by the notes and backup files she had prudently kept at home, Elaine Mercer made two decisions that would ultimately expose one of the largest police corruption scandals in Arizona history. First, she would not resign despite the pressure she knew would intensify. Second, she would find allies outside the compromised systems that had failed her. The next morning, she placed a call to Sofia Vega, an investigative journalist whose reporting on institutional corruption had earned both awards and enemies. Mercer had once considered Vega an adversary, part of a media that often misunderstood police work. Now she represented perhaps the only path forward. "I have a story," Mercer said when Vega answered, "but it's not just a story. It's a cancer, and it's eating the justice system from the inside out." What neither woman knew then was that their conversation was already being monitored. Commander Tanner's influence extended far beyond his precinct, and the system designed to protect the public had been weaponized against those who sought to expose its failures. For Elaine Mercer, the fight for justice was just beginning, and the forces aligned against her were far more powerful and far more ruthless than she yet realized. As her story began to unfold, the archived case that was meant to disappear would instead become the catalyst for a reckoning that would shake the foundations of Arizona law enforcement and ultimately lead to a historic $58 million civil judgment. But first, Mercer would discover just how far the department would go to maintain its code of silence. The first anonymous threat arrived at Sofia Vega's office exactly 3 days after her initial meeting with Elaine Mercer. A plain white envelope containing a single sheet of paper with a message composed of letters cut from magazines. Some stories get journalists killed. No fingerprints, no DNA, no surveillance footage of the delivery. A perfect crime, the kind that suggested law enforcement expertise. Vega, a veteran journalist with the Arizona Republic's investigative team, had built her reputation on exposing corruption in state institutions. The daughter of Mexican immigrants who had faced police harassment in the 1990s, she approached stories about law enforcement with personal insight and professional rigor. She was no stranger to threats, but this one felt different, more immediate, more professional. When a journalist gets threatened, it usually means you're onto something significant, Vega later wrote in her notes. When the threat shows signs of professional execution, it means you're getting close to power. By this point, Commander Blake Tanner had already established himself as one of Phoenix's most visible police leaders. His carefully crafted public image combined tough-on-crime rhetoric with community engagement initiatives that played well in both conservative and liberal media. At 43, with his silver-streaked dark hair and camera-ready smile, he had become a regular presence at city council meetings and charity events, widely rumored to be preparing for a political run. Behind this polished facade, however, Tanner was orchestrating what internal emails would later reveal as Operation Containment, a systematic campaign to isolate, discredit, and ultimately remove Elaine Mercer from the force. On July 12, 2018, the department's psychological evaluation declared Mercer unfit for duty, citing paranoid ideation and inability to maintain professional objectivity. The evaluation was conducted by Dr. Harrison Whitfield, who had no prior history with the department, but was later discovered to be Tanner's former college roommate and the recipient of numerous consulting contracts with the Phoenix PD over the previous 5 years. The evaluation was a joke, recounted Officer Darius Washington, who would later become a key witness. Everyone knew Mercer was being railroaded. The whole precinct was watching, taking notes. The message was clear: this is what happens when you break ranks. As Mercer appealed the psychological evaluation through her union representative, a more insidious campaign was unfolding. Carefully curated rumors began circulating about her mental stability, her personal life, even suggestions of evidence tampering, the very crime she had sought to expose. Personnel records were selectively leaked, including confidential medical information about anti-anxiety medication prescribed after a traumatic shooting incident in 2015. What they did to her was textbook character assassination, explained Dr. Laurel Montgomery, a former FBI behavioral analyst who later consulted on the case. They used intimate knowledge of her history, her vulnerabilities, her professional record, all twisted and recontextualized to create a narrative of instability. It's a sophisticated form of psychological warfare. While Mercer fought for her career, Vega methodically built her investigation, carefully verifying each element of Mercer's claims. She tracked down former suspects who had filed complaints about Officer Dale Preston, one of Tanner's closest allies. She identified patterns in case dismissals that correlated with Tanner's rise through the ranks. Most significantly, she discovered financial irregularities in the department's evidence handling procedures, cash and valuables that were logged during arrests but never reached official evidence storage. By September 2018, as Mercer's appeal was denied and her termination became official, Vega had accumulated enough evidence to justify publishing the first in what would become a Pulitzer-nominated series, Blue Shield: How Phoenix Police Protect Their Own. The article carefully avoided direct accusations, but raised troubling questions about the department's internal accountability systems. The response was swift and severe. Police Commissioner Sullivan held a press conference denouncing the article as irresponsible journalism based on the delusions of a disgruntled former employee. The police union issued a statement questioning Vega's motives and journalistic ethics. Several advertisers temporarily pulled their spots from the Republic's website. Meanwhile, District Attorney Reed Donovan had returned from his unexplained absence, but colleagues noted a profound change in his demeanor. Once outspoken about police accountability, he now declined all comments on the Mercer case or Vega's reporting. When directly questioned by colleagues, he would only say, "Some battles can't be won, some systems can't be fixed." In October 2018, Vega received a breakthrough from an unexpected source. Tyler Kessler, a recently retired police technical analyst, contacted her through an encrypted messaging service with a startling claim. "The body cam footage they said doesn't exist. I know where it is, and I have copies." Kessler, a 30-year veteran of the department's technical division, had been responsible for managing the body camera system since its implementation in 2015. Before his retirement, he had created backups of footage that had been flagged for deletion, suspecting improper handling of evidence. "I didn't know what was on the videos," Kessler later testified. "I just knew that the pattern of deletions didn't follow protocol. Specific officers, specific neighborhoods, specific types of stops, all being erased against procedure. After 30 years in law enforcement, you develop a nose for when something isn't right." The footage Kessler provided revealed a disturbing pattern. Officer Preston and 3 other officers under Tanner's command were routinely disabling their cameras during certain stops, particularly in lower-income neighborhoods. In instances where cameras continued recording, officers could be heard discussing tax collection, an apparent code for unlawful seizure of cash and valuables from suspects unlikely to file formal complaints. Most damning was footage from February 2017, showing Commander Tanner himself at a scene, instructing officers to clean up the narrative in their reports and ensure cameras were off next time. This directly contradicted his sworn statements during the internal review of Mercer's allegations. As Vega prepared to publish these findings, Mercer's personal situation deteriorated rapidly. Unable to secure law enforcement employment with her termination record, she found herself working as a night security guard at a shopping center. Her savings depleted by legal fees, she was forced to sell her home and move to a small apartment on the outskirts of the city. Anonymous calls continued at all hours. Twice, she reported vehicles following her, only to have patrol officers arrive hours later, if at all. On November 15, 2018, the pressure reached a breaking point when Mercer's apartment was broken into while she was at work. Nothing of value was taken, but her case notes were scattered across the floor, and a police department photo of her was left on her pillow, a clear message that she was never beyond their reach. That night, fearing for her safety, Mercer made the difficult decision to leave Phoenix, temporarily relocating to Tucson under an assumed name. Before leaving, she reached out to one final contact, federal prosecutor Amara Davidson, known for her work on police corruption cases in neighboring New Mexico. "The local system is compromised beyond repair," Mercer told Davidson in their first meeting. "This isn't just about me anymore. It's about a department that believes it's above the law." As 2018 drew to a close, what had begun as one officer's stand against misconduct was evolving into something far larger and more dangerous, an exposure of systematic corruption that reached into the highest levels of Phoenix law enforcement and city government. For those involved in maintaining the department's code of silence, the stakes were now too high to allow failure. And in the shadows, watching the scandal unfold with growing concern, were powerful figures whose connections to Commander Tanner extended far beyond professional courtesy. Figures who stood to lose everything if the full extent of the corruption was exposed. The first snowfall of January 2019 blanketed Tucson in an unusual white silence. In a small rented cabin on the outskirts of the city, Elaine Mercer watched the snow accumulate with a detachment that had become her emotional baseline. 3 months into her self-imposed exile, she had established a sparse routine: security shifts at a local warehouse, daily runs regardless of weather, and endless hours reviewing her case notes, searching for patterns she might have missed. Her phone rang rarely these days, a deliberate isolation strategy to protect the few allies she had left. When it did ring on that snowy morning, the name that appeared, Sofia Vega, sent a jolt of adrenaline through her system. "They're destroying evidence," Vega said without preamble. "Kessler's contact in technical services says there's been an emergency server migration, ordered directly by Commissioner Sullivan. They're moving all body cam footage from the last 3 years to new storage systems, and files are mysteriously corrupting during transfer." What neither woman knew then was that Tyler Kessler had implemented a contingency plan months before his retirement. Anticipating potential evidence tampering, he had created encrypted backups of the most damning footage, stored on servers outside the department's control. As a systems administrator with decades of access, Kessler had observed the gradual corruption of the department and had quietly documented it, unsure if he would ever have the courage to act on his knowledge. "I wasn't a brave man," Kessler later testified. "I spent 30 years looking the other way on minor infractions because that's what the culture demanded. But when I saw Commander Tanner's unit operating what amounted to an extortion racket, something broke inside me. I realized I'd spent my career enabling a system that betrayed everything it claimed to stand for." Kessler's evidence cache included not only body cam footage but internal emails, duty rosters, and financial records, showing discrepancies between reported seizures and logged evidence. Most significantly, it contained metadata proving that footage claimed to be never recorded had in fact been deliberately deleted from the system, a felony under Arizona evidence handling laws. On February 3, 2019, federal prosecutor Amara Davidson met with her superiors at the Justice Department, presenting Mercer's allegations along with the preliminary evidence provided by Kessler and Vega. The response was cautious. Corruption cases against police departments were politically sensitive and required ironclad evidence before federal resources would be committed. "Come back when you have more than allegations and some potentially doctored videos," her supervisor advised. "We need witnesses willing to testify, paper trails, patterns that can't be explained away as administrative errors." Davidson, the daughter of a Detroit police officer who had been ostracized for reporting corruption in the 1980s, understood the personal costs of such cases. She also recognized their importance. "The integrity of our justice system isn't an abstract concept," she wrote in her case notes. "When citizens can't trust the police, when officers can't trust their chains of command, the entire foundation of public safety crumbles. This case isn't just about corrupt officers. It's about whether we truly believe in equal justice under law." While Davidson navigated federal bureaucracy, Vega published her second major exposé, The Digital Cover-Up: How Phoenix Police Manipulate Body Camera Evidence. The article detailed specific instances where footage had been deleted or misclassified, directly contradicting official statements about technical limitations or officer error. The response from Phoenix PD was immediate and aggressive. Commissioner Sullivan announced an investigation into criminal leaking of confidential police data and suggested that the footage had been manipulated by disgruntled former employees with technical expertise and personal vendettas. The police union held a vote of no confidence in the Arizona Republic's reporting and encouraged officers to refuse interviews with any of its journalists. Perhaps most troubling was the response from District Attorney Reed Donovan's office, which issued a terse statement. "The district attorney has reviewed the allegations and found insufficient evidence of criminal misconduct by any Phoenix Police Department personnel." This directly contradicted Donovan's initial response to Mercer's evidence nearly a year earlier. As public attention intensified, a forensic data specialist hired by the Arizona Republic confirmed the authenticity of Kessler's footage. Independent experts verified that the deletion patterns couldn't be explained by technical malfunctions or user error. The systematic nature of the evidence tampering became increasingly difficult to dismiss. In late February, the case took an unexpected turn when Officer Jaden Rivera, a 3-year veteran from Tanner's precinct, was found dead in his apartment, an apparent suicide. His service weapon lay beside him, along with a note apologizing to his family, but providing no specific explanation for his actions. 2 days later, Vega received an encrypted email from an anonymous account. Rivera wasn't suicidal. He was preparing to talk, check his academy connection to Mercer. Research revealed that Rivera had been in the same academy class as Mercer 6 years earlier. Former classmates described them as casual friends who had lost touch after being assigned to different precincts. Nothing in their known history suggested why Rivera might have had information relevant to Mercer's case. The breakthrough came from Rivera's partner, Officer Louis Chen, who contacted Vega through an anonymous tip line. According to Chen, Rivera had been struggling with his conscience for months after witnessing Officer Preston plant evidence during a drug arrest. When Rivera had questioned the practice, Preston explained that it was departmental policy in certain neighborhoods to maintain statistics and keep known offenders off the streets by any means necessary. Rivera was a good cop, Chen later testified. He believed in doing things by the book. After the incident with Preston, he started documenting similar cases, building his own file. The week before his death, he told me he was thinking about taking his concerns up the chain of command. I warned him about what happened to Mercer, but he said some things were worth the risk. Phoenix PD quickly classified Chen's allegations as unsubstantiated hearsay from an officer facing his own disciplinary issues, a reference to a recent performance review that had suddenly flagged Chen for attention to procedural detail. The department's swift effort to discredit Chen only reinforced the pattern of retribution against officers who broke the code of silence. By March 2019, what had begun as Mercer's isolated stand against departmental misconduct had evolved into a complex web of allegations, evidence, and increasingly suspicious circumstances. Pressure mounted on federal authorities to intervene as public trust in local law enforcement and judicial oversight deteriorated. The catalyst for federal action finally came from an unexpected source. Amanda Lockhart, the county's chief medical examiner, quietly contacted Davidson with concerns about Officer Rivera's autopsy. The bullet trajectory, gunpowder residue pattern, and lack of hesitation marks were inconsistent with typical self-inflicted wounds. More troublingly, the toxicology report showed high levels of sedatives not prescribed to Rivera and not found in his apartment or medical records. "I can't officially rule this a homicide without more evidence," Lockhart explained, "but I've worked hundreds of suicides, and this doesn't fit the profile. Someone went to considerable effort to make this look self-inflicted." Davidson immediately took this information to her superiors, who finally authorized a preliminary federal investigation. On April 12, 2019, FBI agents from the Phoenix field office began interviewing officers from Tanner's precinct, focusing initially on evidence handling procedures and body camera protocols. As federal involvement became public, a subtle shift occurred within the department. Junior officers, sensing changing political winds, became more cooperative. Administrative staff, previously reluctant to contradict official narratives, began providing documents showing alterations to evidence logs and personnel files. The wall of silence, maintained for years through intimidation and professional pressure, showed its first significant cracks. For Elaine Mercer, watching these developments from her self-imposed exile, the emotional impact was complex. Vindication came with the knowledge that her allegations were finally being taken seriously, but it was overshadowed by Rivera's death and the realization that the corruption she had uncovered was even more dangerous than she had initially believed. "I keep thinking about the butterfly effect," she confided to Vega during a rare phone call. "If I had approached this differently, if I had gathered more evidence before going official, if I had built a stronger coalition within the department, would Rivera still be alive? Would fewer people have been hurt by this system?" As spring arrived in Arizona, bringing desert wildflowers and renewal to the landscape, the investigation entered a new phase. What had begun as one officer's stand against misconduct had become a federal case that would eventually expose decades of systematic corruption. For Commander Tanner and his allies, the carefully constructed network of protection and profit was beginning to unravel, and they would not surrender their power without a fight. The evidence hidden by Kessler and the testimony of officers like Chen had cracked open the case, but the full extent of the corruption and its connections beyond the police department remained concealed, protected by powerful figures who had benefited from Tanner's operation for years. As federal investigators dug deeper, they would soon discover that the corruption extended far beyond a rogue commander and his loyal officers, reaching into the highest levels of Phoenix power structures. The first connection appeared innocuous: a charity golf tournament in May 2019, where photographs showed Commander Blake Tanner laughing alongside real estate developer Victor Garrison. Records would later reveal that Garrison's company, Phoenix Horizon Development, had acquired 17 properties in low-income neighborhoods where Tanner's officers conducted their most aggressive enforcement operations. Properties that had plummeted in value following police raids suddenly appeared in Garrison's portfolio, purchased at fractions of their market value. FBI financial analyst Meera Patel, assigned to the expanding investigation, identified the pattern during a routine review of property records. "The correlation was too consistent to be coincidental," she noted in her case files. "Within 6 months of intensified police activity, property values in targeted blocks dropped 30–45%. Within another 3 months, Phoenix Horizon would acquire multiple parcels. A year later, after enforcement mysteriously decreased, redevelopment would begin and values would triple. This discovery transformed the scope of the investigation from departmental corruption to what prosecutors would later call systematic exploitation of law enforcement powers for private financial gain, a criminal enterprise operating under the guise of community policing. By June 2019, as the FBI's investigation intensified, key figures began taking defensive positions. Commissioner Sullivan announced his early retirement, citing health concerns. District Attorney Reed Donovan, once known for his prosecutorial zeal, withdrew from public view, canceling appearances and delegating responsibilities to subordinates. Most tellingly, Commander Tanner requested a transfer to administrative duties, claiming a desire to focus on departmental policy improvements. These calculated retreats came too late. FBI agents had already secured warrants for phone records, financial statements, and email accounts. The electronic trail revealed communications between Tanner, Garrison, and a network of influential Phoenix figures, including Councilman Warren Mitchell, who chaired the city's zoning commission, and Judge Eleanor Briggs, who had consistently approved warrants for raids in neighborhoods later targeted for redevelopment. "What we found wasn't just corrupt officers," explained Special Agent Derek Winters, who led the FBI's operational team. "It was a sophisticated influence operation. Tanner's unit would intensify enforcement in neighborhoods identified for potential development. The resulting crime statistics would justify continued pressure. Property values would plummet. Garrison's shell companies would acquire the properties. Mitchell would expedite rezoning. Judge Briggs would ensure legal obstacles were cleared, and everyone involved received financial benefits, carefully obscured through a network of LLCs and offshore accounts. The scheme had operated with remarkable efficiency for nearly 8 years, generating estimated profits exceeding $75 million while displacing hundreds of families from historically Black and Hispanic neighborhoods. Most disturbingly, it had weaponized legitimate concerns about crime and community safety to serve private interests, corrupting the very institutions meant to protect the public. As federal investigators assembled their case, Elaine Mercer finally emerged from hiding, returning to Phoenix in July 2019 to provide formal testimony. Her arrival at the federal courthouse, accompanied by federal prosecutor Amara Davidson, marked her first public appearance since her dismissal from the force. The media presence was substantial, but Mercer maintained a composed demeanor, her expression betraying nothing of the personal toll the past year had taken. "I'm here because the truth matters," she stated briefly to reporters. "The public deserves law enforcement that serves justice, not private interests." Inside the grand jury room, Mercer spent 11 hours detailing her investigation, methodically connecting evidence that now formed the foundation of the federal case. Her testimony, later described by jurors as meticulous and unimpeachable, established the timeline of corruption and the systematic efforts to conceal it. While the grand jury proceedings remained confidential, their impact became evident when FBI agents executed simultaneous raids on August 3, 2019, targeting 16 locations, including Tanner's residence, Garrison's offices, and the private chambers of Judge Briggs. The evidence seized, including financial records, communication devices, and physical documents, filled 27 evidence boxes and 4 digital storage servers. The most damning evidence came from an unexpected source. Councilman Mitchell, recognizing the extent of the investigation, negotiated a cooperation agreement in exchange for leniency. His testimony opened new avenues of inquiry, implicating additional public officials and revealing how the scheme had evolved from opportunistic corruption to a systematic criminal enterprise. "For it started small," Mitchell testified. Tanner would provide advance notice of enforcement operations to Garrison, who would position investors to acquire distressed properties. But as they saw the potential, it became more organized. They began selecting neighborhoods specifically for their development potential, manufacturing crime statistics to justify enforcement surges, and leveraging political connections to facilitate rapid redevelopment once properties had been acquired. Mitchell's cooperation precipitated a cascade of plea negotiations as lower-level participants sought to minimize their exposure. By September 2019, 5 officers from Tanner's unit had agreed to testify against their former commander, providing detailed accounts of how they had been gradually drawn into criminal activity through a combination of incentives and intimidation. Officer Zachary Walsh described the process. "It starts with small compromises, looking the other way on minor infractions, accepting gift cards as thank you gestures from Tanner. Then it escalates. You're told to focus enforcement on specific blocks, to make arrests that won't hold up but will generate statistics. By the time you realize you're part of something corrupt, you're already implicated enough that speaking out seems impossible." As the case expanded, so did public awareness of its implications. Sofia Vega's reporting evolved from exposing departmental misconduct to documenting a criminal conspiracy that had reshaped Phoenix's urban development. Community activists in affected neighborhoods formed advocacy groups, identifying hundreds of families who had been displaced by the artificial cycle of enforcement and redevelopment. The human impact became increasingly central to the narrative. Maria Delgado, a 73-year-old grandmother who had lost her family home of 40 years following a mistaken drug raid, became a powerful symbol of the scheme's victims. The raid, based on falsified information from one of Tanner's officers, had found no evidence of criminal activity, but the trauma and legal costs had forced Delgado to sell her property for a fraction of its value to one of Garrison's shell companies. "They took more than my house," Delgado told reporters. "They took my neighborhood, my community, my sense of safety. And they did it with badges and legal papers, so who could I turn to?" Stories like Delgado's transformed public perception of the case from an abstract corruption scandal to a fundamental violation of community trust. Calls for accountability extended beyond the immediate perpetrators to the systems that had enabled them. The lack of oversight, the intimidation of whistleblowers, and the political structures that had prioritized development interests over community welfare. By October 2019, federal prosecutors had assembled enough evidence to present a comprehensive case to the grand jury. The resulting indictment named 23 defendants, including Tanner, Garrison, Judge Briggs, and former District Attorney Donovan, who was alleged to have deliberately suppressed Mercer's evidence in exchange for campaign contributions and promises of political support. The charges were extensive: racketeering, conspiracy, extortion, mail and wire fraud, civil rights violations, obstruction of justice, and witness tampering. If convicted on all counts, the principal defendants faced potential sentences exceeding 30 years. The indictment also included asset forfeiture provisions, targeting an estimated $82 million in illegal proceeds. The arrests, conducted in a coordinated operation on October 28, 2019, generated national headlines. Images of Commander Tanner, once the department's media-savvy public face, being led from his home in handcuffs, symbolized the dramatic reversal of fortune. Judge Briggs, who had signed countless warrants enabling the scheme, now found herself subjected to the justice system she had compromised. For Elaine Mercer, watching these developments from the small apartment she had rented upon returning to Phoenix, the emotions were complex. The vindication was undeniable, but it came with a profound awareness of what had been lost: her career, her financial stability, her sense of security, and most painfully, her faith in the institutions she had once proudly served. "Justice is being done," she acknowledged during a rare interview with Vega, "but it can't restore what was taken from so many people, not just from me, but from every community that suffered under this corruption, from every honest officer whose work was tainted by association, from every citizen whose trust in law enforcement was betrayed." As 2019 drew to a close, the criminal proceedings against Tanner and his co-conspirators were just beginning. Yet already, the case had fundamentally altered Phoenix's political and law enforcement landscapes. Reform initiatives gained momentum, oversight mechanisms were strengthened, and a new generation of leaders emerged, committed to rebuilding institutional integrity. Meanwhile, in the background, Mercer's legal team was quietly preparing another front in the battle for accountability, a civil action that would ultimately result in one of the largest settlements ever awarded to a law enforcement whistleblower. The criminal prosecution would address the public wrongs, but the civil case would seek justice for the personal destruction of a career dedicated to public service. The web of corruption, meticulously constructed over nearly a decade, had finally unraveled. What remained was the long process of accountability, reconciliation, and reform, a process that would test whether systems could truly change and whether justice delayed could still serve its essential purpose. The Phoenix Federal Courthouse stood as an architectural embodiment of judicial authority, imposing limestone columns, soaring ceilings, and the ever-present weight of legal consequence. On January 13, 2020, this monument to justice became the stage for what prosecutors called the most significant public corruption case in Arizona's modern history, as pre-trial hearings began in United States versus Tanner et al. Special Agent Lydia Nolan, a 15-year veteran of the FBI's Public Corruption Unit, had been assigned as lead investigator following the initial findings. Known for her methodical approach and unshakable testimony, Nolan had built her career dismantling corrupt systems from New Orleans to Chicago. Yet even she found the Phoenix case exceptional in its scope and sophistication. "Most corruption cases involve individual actors seeking personal gain," Nolan explained in her case summary. What distinguished the Phoenix operation was its systematic integration into legitimate governmental functions. They didn't just break the law, they weaponized it, using enforcement powers, judicial authority, and legislative influence as tools for private enrichment. As the federal case expanded, so did its implications. Financial forensics revealed that the corruption extended beyond real estate manipulation. Evidence emerged of protection schemes involving nightclubs and cash businesses, selective enforcement against competitors of allied business interests, and the strategic deployment of police resources to serve private rather than public safety objectives. The pretrial phase brought a series of revelations that shocked even seasoned observers. Former District Attorney Reed Donovan, facing potential decades in prison, negotiated a cooperation agreement that provided devastating insights into the operation's political protection mechanisms. His testimony revealed how Tanner had cultivated relationships throughout Arizona's power structures, leveraging police endorsements, campaign contributions, and selectively targeted investigations to ensure political cover for the criminal enterprise. Commander Tanner understood that traditional corruption is vulnerable, Assistant U.S. Attorney Marcus Hamilton explained during the preliminary hearing. His innovation was creating a network where each participant's interests aligned with the scheme's continuation. Officials received campaign support and favorable media coverage. Developers made millions on artificially devalued properties. The department received increased funding based on enforcement statistics. It was corruption designed as a self-sustaining ecosystem. By February 2020, as the case proceeded toward trial, public attention increasingly focused on the systemic failures that had allowed the corruption to flourish. Internal affairs protocols, civilian oversight mechanisms, and departmental whistleblower protections had all proven inadequate when tested. The case had exposed not just individual criminality, but institutional vulnerability to capture by corrupt influences. For Elaine Mercer, the federal proceedings brought a measure of validation, but little personal relief. While her allegations had been vindicated, her professional identity remained shattered. Job applications to other law enforcement agencies were met with polite rejections. Her role as a whistleblower, making her simultaneously heroic in public perception and unemployable within police culture. The Blue Wall doesn't forgive, explained Dr. Catherine Morrow, a criminologist specializing in police culture. Even departments that officially support accountability tend to view whistleblowers as potential liabilities. The officer who exposes corruption is still seen as someone who broke ranks, regardless of the justification. Mercer's financial situation had become increasingly precarious. Legal expenses had depleted her savings, while the protracted nature of the proceedings prevented her from rebuilding her career. She had transitioned from night security work to a position as a loss prevention manager at a retail chain. Steady employment, but a shadow of the career she had built over 12 years in law enforcement. The turning point came in March 2020, when attorney Julian Ramirez approached Mercer about pursuing civil action against the city, the police department, and individual defendants. Ramirez, whose practice specialized in whistleblower and civil rights cases, had been following the criminal proceedings with professional interest. "What happened to you wasn't just criminal, it was a constitutional violation," Ramirez told Mercer during their first meeting. "They used state power to punish protected speech, to retaliate against lawful reporting of misconduct, and to deprive you of your career and reputation without due process. These are fundamental civil rights violations that exist independently of the criminal case." The civil complaint, filed on April 7, 2020, detailed 57 specific acts of retaliation, ranging from professional sabotage to intimidation and harassment. Unlike the criminal case, which focused on the broader conspiracy, the civil action specifically addressed the personal harm inflicted on Mercer as a direct consequence of her protected disclosures. City attorneys initially dismissed the lawsuit as opportunistic and lacking merit, predicting it would be promptly dismissed once the emotional narrative is separated from the legal facts. This dismissive approach would prove to be a significant strategic error, as it positioned the city in direct opposition to the mounting evidence of wrongdoing emerging from the federal criminal proceedings. As both cases advanced through their respective legal channels, they created a powerful synergy. Evidence secured through federal criminal discovery became available for the civil proceedings. Witnesses who had cooperated with prosecutors provided additional testimony for the civil case. The parallel proceedings created a comprehensive legal framework for accountability that addressed both public and personal dimensions of the corruption. By summer 2020, the criminal case had become too overwhelming for many defendants to contest. Plea negotiations accelerated as the extent of federal evidence became clear. Judge Eleanor Briggs was the first major figure to accept a plea arrangement, admitting to conspiracy and honest services fraud in exchange for a recommended sentence of 7 years and cooperation against remaining defendants. Her testimony provided crucial insights into how the corruption had compromised judicial independence. Briggs described how Tanner had initially approached her with seemingly legitimate concerns about warrant efficiency for narcotics enforcement, gradually drawing her into a system where warrants were expedited for targeted neighborhoods while receiving subtle benefits including campaign donations, positive media coverage, and social connections to Phoenix's elite circles. It was like the parable of the boiling frog, Briggs testified. There was never a moment where I consciously decided to become corrupt. There was just a series of small compromises, each seemingly justifiable in isolation, until suddenly I realized I was approving warrants I knew were legally insufficient because they served a larger scheme I had become dependent on. This pattern of incremental corruption emerged as a common theme across defendant testimonies. Few had entered their careers intending to become criminal conspirators. Instead, the system had gradually normalized ethical compromises, reframing corruption as pragmatism and resistance as naivety. By August 2020, as the remaining criminal defendants prepared for trial, the human cost of the corruption scheme became increasingly central to public discourse. Community organizations in affected neighborhoods compiled documentation of over 200 families who had been displaced by the artificial cycle of enforcement and redevelopment. Economic analyses estimated that the scheme had extracted over $120 million in property value from predominantly minority communities. These findings reinforced the growing recognition that the corruption had not just violated laws, but had weaponized the justice system against vulnerable communities. The scheme had exploited existing social inequities, using enforcement disparities that were already normalized to advance private financial interests. The Federal Bureau of Prisons estimated that the cost of incarcerating individuals on charges stemming from Tanner's fabricated or exaggerated cases exceeded $15 million over the 8-year period. The human cost, in disrupted lives, separated families, and lost opportunities, proved impossible to quantify, but impossible to ignore. On September 15, 2020, as jury selection for the criminal trial was set to begin, Commander Blake Tanner finally accepted a plea agreement. In exchange for a reduced sentence recommendation of 15 years, he provided comprehensive testimony about the operation he had orchestrated, including naming additional co-conspirators who had not yet been charged. His plea statement, read in open court, offered a rare glimpse into the mindset that had justified such extensive corruption. I began with the belief that the ends justified the means, that aggressive enforcement served community safety even when procedures weren't perfectly followed. Over time, I convinced myself that personal benefit was justified compensation for public service. The system encouraged this thinking at every level, rewarding statistics over substance and perception over reality. As the criminal cases resolved through pleas and limited trials, attention increasingly shifted to Mercer's civil action, which had advanced to discovery phase. Depositions of department officials revealed a culture of retaliation that extended far beyond Mercer's case, with multiple officers describing how reporting misconduct was career suicide within the department. Internal communications obtained through discovery showed that Mercer's psychological evaluation had been deliberately manipulated, with the examiner receiving specific guidance on desired conclusions before ever meeting her. Personnel records revealed systematic efforts to retroactively document performance issues that had never been raised during her 12 years of consistently positive evaluations. Most damning were emails between Commissioner Sullivan and Commander Tanner explicitly discussing how to neutralize the Mercer problem and ensure she would be unemployable in law enforcement anywhere in the Southwest. These communications, secured through the federal criminal investigation, transformed Mercer's civil case from a contestable claim to what legal observers increasingly described as indefensible. By December 2020, as the criminal sentencing phase began for early plea agreements, federal authorities had established a special task force to address the broader implications of the case. The Phoenix Police Department was placed under a consent decree requiring comprehensive reforms in accountability systems, evidence handling procedures, and whistleblower protections. For Elaine Mercer, watching as the systems she had challenged were finally forced to change, the victory remained bittersweet. The corruption had been exposed, the perpetrators were facing consequences, and reforms were being implemented, yet her personal and professional life remained in ruins, a casualty of having done exactly what her oath of office had required. As 2020 drew to a close, her civil case moved inexorably toward trial, carrying with it the possibility of personal vindication that the criminal proceedings, focused on public accountability, could not provide. The federal case had established the crimes. The civil action would determine whether the system that had failed her would now be required to make her whole. On a crisp morning in February 2021, Courtroom 4B of the Maricopa County Superior Court fell silent as Judge Marcus Wilson delivered his ruling on the city's motion to dismiss Elaine Mercer's civil lawsuit. The packed gallery, journalists, legal observers, and community members who had followed the case leaned forward collectively, sensing a pivotal moment. The city's argument that Ms. Mercer's claims are without merit strains credibility in light of the extensive criminal convictions already secured in federal court, Judge Wilson stated, his tone measured but pointed. The evidence establishes, at minimum, sufficient grounds to proceed to trial on all counts. This court finds particularly troubling the suggestion that a law enforcement officer who reports criminal activity within her department should be left without remedy when that department retaliates against her using the very governmental powers she sought to protect from corruption. With that ruling, Mercer v. City of Phoenix et al. Officially proceeded to trial, scheduled for May 2021. The city's legal strategy, which had relied on procedural dismissals and technical challenges, now shifted toward damage control and settlement considerations as the prospect of public testimony loomed. By this point, the federal criminal case had resulted in 17 convictions through pleas and trials. Commander Blake Tanner had received a 14-year sentence for racketeering, conspiracy, and civil rights violations. Real estate developer Victor Garrison was serving 11 years for his role in the scheme. Former Judge Eleanor Briggs had received 7 years as part of her cooperation agreement. The remaining defendants had received sentences ranging from probation to 10 years, depending on their level of involvement and cooperation. The criminal proceedings had focused on accountability for past actions, but Mercer's civil case raised more fundamental questions about systemic responsibility. Unlike the criminal trials, which examined individual culpability, the civil action directly challenged institutional failures, the policies, cultures, and oversight mechanisms that had not just permitted corruption, but actively punished those who reported it. The criminal cases established what these individuals did wrong, explained legal analyst Marion Chen, who had covered the proceedings for the National Law Journal. The civil case asks a different question. What did the system do wrong, and what does it owe to those who were damaged when they tried to protect it? As trial preparation intensified, the city's legal team found their position increasingly untenable. Depositions of current and former officials revealed a pervasive culture of retaliation against officers who reported misconduct. Internal documents showed that Mercer's termination had been orchestrated at the highest levels, with her psychological evaluation predetermined before she ever met with the examiner. Most damaging was testimony from officers who had remained silent during Tanner's corruption, citing Mercer's fate as their rationale. "We all saw what happened to her," Officer Miguel Santos testified in his deposition. "She did everything by the book, reported through proper channels, had solid evidence, and they destroyed her. The message was crystal clear. This is what happens when you break the blue wall of silence." Public sentiment had shifted dramatically since Mercer's initial allegations in 2018. What had once been dismissed as the claims of a disgruntled employee was now widely recognized as one of the most significant acts of ethical courage in Arizona law enforcement history. Community groups organized rallies supporting her case, while police reform advocates cited her experience as evidence of the need for stronger whistleblower protections. On April 12, 2021, 3 weeks before the scheduled trial, the city's attorneys approached Mercer's legal team with a settlement offer of $2 million. The proposal included a non-disclosure agreement that would prevent Mercer from discussing her experiences or the department's actions against her. Attorney Julian Ramirez presented the offer to Mercer in his office, explaining the practical considerations. "This is substantial compensation for your financial losses, and it eliminates the uncertainty of trial. However, the silence requirement is absolute. You would never be able to speak publicly about what happened to you or how the department responded to your reports." Mercer considered the offer for less than a minute before declining. "This was never about money," she told Ramirez. "It's about accountability and change. They're not offering justice. They're offering hush money to keep the system's failures from being fully exposed at trial. I didn't come this far to have my voice silenced now." Her decision to proceed to trial represented significant financial risk. While the evidence strongly supported her claims, jury verdicts remained unpredictable. and the city had resources to appeal any outcome. Yet for Mercer, the principle transcended practical considerations. The system that had failed her needed to be publicly examined, not protected through confidential settlements. When trial commenced on May 17, 2021, public interest had reached unprecedented levels. The courtroom was filled to capacity each day, with overflow rooms established to accommodate observers. National media covered the proceedings as a landmark case in police accountability and whistleblower protection. Unlike the criminal trials, which had focused on complex financial schemes and legal technicalities, Mercer's civil case presented a profoundly human narrative. Her testimony, delivered over 3 days, methodically recounted her journey from dedicated officer to department pariah, detailing the systematic dismantling of her career and reputation. "The most painful part wasn't losing my job," she testified. "It was watching a system I believed in, a system I had dedicated my life to, turn against me for doing exactly what my oath required. They didn't just attack my career, they attacked my identity, my purpose, my sense of belonging to a profession I had always seen as a calling." The city's defense strategy focused on procedural justifications, arguing that each action against Mercer had followed established protocols and policies. This approach backfired dramatically when Mercer's legal team demonstrated that those very protocols had been weaponized as retaliation tools, with officials selectively applying regulations that were routinely ignored in other cases. Expert testimony from Dr. Samuel Richards, a nationally recognized authority on police organizational culture, contextualized Mercer's experience within broader patterns of whistleblower retaliation in law enforcement. What happened to Officer Mercer wasn't an anomaly, it was the predictable result of a system designed to protect itself from internal criticism. The tragedy is that the officers most committed to ethical policing are precisely the ones most vulnerable to this form of institutional retaliation. After 6 weeks of testimony, the case went to the jury on June 29, 2021. Deliberations lasted just over 3 days before they returned with their verdict. Mercer had proven all 57 claims of retaliation, establishing that the department had violated her constitutional rights, engaged in wrongful termination, inflicted emotional distress, and damaged her professional reputation through coordinated actions intended to punish protected whistleblowing. The damage award, announced on July 3, 2021, stunned even experienced legal observers. $7 million in compensatory damages for lost wages, benefits, and career opportunities. $3 million for emotional distress, reputation damage, and security costs incurred during her period in hiding. And most significantly, $37 million in punitive damages intended to deter similar conduct in the future. The total judgment of $58 million represented one of the largest whistleblower verdicts in American history and the largest ever awarded against an Arizona governmental entity. Beyond its financial implications, the verdict established crucial legal precedent regarding the constitutional protections afforded to law enforcement officers who report corruption within their departments. The city immediately announced plans to appeal, characterizing the verdict as excessive and disproportionate. However, public reaction strongly supported the outcome, with polls showing that 73% of Phoenix residents believed the award was justified given the extent of retaliation and the importance of protecting whistleblowers. On August 15, 2021, facing intense public pressure and the likelihood of an unsuccessful appeal, the City Council voted 6-3 to accept the verdict without further litigation. Mayor Sofia Rodriguez, elected on a reform platform following the corruption scandal, addressed the decision at a press conference. While this settlement imposes significant financial costs on our city, continuing to fight would impose far greater moral costs. Officer Mercer did exactly what we should expect from those entrusted with public authority. She stood against corruption at tremendous personal risk. Our responsibility now is not just to compensate her for that sacrifice, but to ensure that no officer ever faces similar retaliation for upholding their oath. The settlement agreement included provisions beyond financial compensation. The department was required to establish enhanced whistleblower protections, create an independent review board for retaliation complaints, and implement mandatory ethics training focusing on the duty to report misconduct. Most symbolically, the Police Academy's Ethics Center was renamed the Elaine Mercer Center for Police Integrity. For Mercer herself, the verdict brought validation, but not restoration. No financial award could recover the years lost, the career derailed, or the sense of purpose diminished. In her only public statement following the verdict, she reflected on this bittersweet reality. Justice delayed is often described as justice denied, and there's truth in that. This verdict can't give me back the career I loved or erase the years of isolation and fear. What it can do is establish that standing for truth has value, that ethical courage deserves protection, and that systems must be held accountable when they punish integrity instead of rewarding it. In the months following the verdict, Mercer established the Whistleblower Protection Foundation, using a portion of her award to provide legal, financial, and emotional support to public employees who report corruption and face retaliation. The foundation's work quickly expanded beyond law enforcement to include all public service sectors, creating a support network that had not existed when Mercer had stood alone. By late 2021, the Phoenix Police Department had implemented comprehensive reforms under federal oversight. New leadership emphasized transparency and accountability, with particular attention to creating safe reporting channels for officers who witness misconduct. While institutional culture would require years to truly transform, the structural changes represented significant progress toward the values Mercer had sacrificed her career to defend. The case that began with one officer's refusal to ignore corruption had culminated in systemic change, legal precedent, and a powerful statement about the essential role of individual conscience in maintaining public integrity. For Elaine Mercer, justice had indeed been delayed, but in its arrival, however belated, it had catalyzed protections that would serve future generations of public servants faced with similar moral challenges. In police academies across America, her story became a case study in ethical courage and the costs of maintaining integrity in corrupted systems. The lesson was both cautionary and inspiring. Standing alone against institutional power carries profound personal risk, yet such stands remain essential to the functioning of democratic institutions and the rule of law. The $58 million verdict served not just as compensation for one officer's destroyed career, but as a public reckoning with the cost of silence, the value of truth, and the ongoing struggle to ensure that those who enforce the law remain subject to it, a struggle that continues in police departments and public institutions across the nation.